Good morning. Today let us, today let us discuss directive principles of state policy, and it is mentioned in part 4 of the Indian Constitution and articles 36 to 51. So these articles put together is called part 4, and the subject content that is present in part 4 is the directive principles of state policy. And in short, we'll be using the word DPSP. But I would like to remind one thing to you. In DPSP, the word state is very, very important for us. In the previous classes, I have explained you the meaning of the state in a very detailed manner. Just to recollect that meaning, that is important for us to understand these concepts in a better manner. And another one, whatever this DPSP we are going to talk, these DPSP is considered to be non-justiciable. What do you mean by this? Yesterday, when we are talking about the fundamental rights, I used these words. Fundamental rights are justiciable, but DPSP are non-justiciable. If there is a violation of the fundamental rights, we can approach the judiciary, and the judiciary will look into our issues if there is any infringement in our fundamental rights. But when it comes to directive principles of state policy, these are the responsibilities, these are the duties that should be performed by the government, that should be performed by the state. And wherever you are coming across with the word state, it should be always a welfare state. And that state, because of any reason, if it cannot perform any function that is mentioned in the DPSP, we cannot challenge in the court of law. This is what the Constitution is saying. That's the reason why we are using the word non-justiciability of DPSP. This is one fundamental difference between fundamental rights and the directive principles of state policy. If there is a question in the examination where you will be asked to compare fundamental rights and DPSP, you will be writing so many things, but in the beginning, what you are supposed to write is that fundamental rights are justiciable, whereas DPSP is a non-justiciable. That's it. That's the point. Am I clear? Now, so first we'll look into all the DPSP that is present from articles 36 to 51. Then we'll look into some of the case laws. So these are the cases that were dealt by the Supreme Court, and what are the judgments that are given by the Supreme Court in various cases, and what Supreme Court has said with respect to fundamental rights and DPSP. Let me open the document straight away, and I will talk to you regarding the directive principles of state policy. Now, look at this. Right. This DPSP is mentioned under Part 4 of the Indian Constitution, and articles are 36 to 51. Right? Look at this. This DPSP are considered to be the needs of the community. By looking at the necessities that are required in the community, these directive principles have been framed. And when it comes to the point number 2, this we already know. While talking about the sources of the Indian Constitution, we made it very clear that the DPSP was borrowed from Ireland Constitution or Irish Constitution. Look at this. These are the recommendations to the state. These are the recommendations to the state in legislative, executive, and administrative matters. In the brackets here, you just read it what I have given. State means legislative and executive organs of the central and state governments, all local authorities, and all other public authorities in the country. Just to recollect what I told you under Article number 12 of the Indian Constitution. The same thing we are going to repeat even in Article number 36 of the Indian Constitution. This is the meaning of the state. Now, I am highlighting this point. This is another important point with respect to objective type of examination. The Government of India Act 1935, instrument of instructions, they were enumerated, and in the Indian Constitution they are called DPSP. Very important. Whatever I am using the word DPSP now, in fact they were enumerated in instrument of instructions, which was a part of the Government of India Act 1935. And in our constitution today, we are using the word directive principles of state policy. When it comes to DPSP, they embody the concept of welfare state. So this is the word what I was using from day number 1. So DPSP will always aim at the welfare of the state. The inspiration for DPSP came from the concept of the welfare state. And the directive principles are considered to be the operative part of the Constitution. What do you mean by operative part? Operative part is nothing but the government must function. The government should execute. The state should function. And what functions that you are supposed to perform is nothing but the directive principles of the state policy. That's the reason DPSP is considered to be operative part of the Constitution. Now, through DPSP, the Constitution seeks to achieve the ideals of the democratic welfare state. We have seen what is the meaning of the democracy. In the democracy, highest regard and respect should be given to the people. So because the government is formed with the support of the people, because the people are coming out and people are voting in the elections. Accordingly, after formation of the government, the organ or the political people who are present in the government, they should work for the welfare of the society. That's the reason the political party which is there in the power will play a crucial role as far as the welfare of the state is concerned. But how exactly they will perform? The government will prepare the policies and the policies must be implemented. At the time of implementation, the administration comes into the picture. When I am using the word administration, this is nothing but, administration is nothing but the government employees. And the government employees may be at the central level, state level, or at the local level. Their responsibility is to implement the policies that are prepared by the government of the day. Hence, always there is a coordination between politicians, meaning the political party which is there in the power, and the administration which is going to implement the policies. In the absence of any two, the welfare state concept cannot be achieved. One organ is preparing the policy, another organ is implementing those policies. Both are important for us. That's the reason when I'm using the word state, I'm including the legislative part and also the administrative part. Hence, I'm also including the government employees in this particular concept called state. Kindly remember, you will also become the government employees tomorrow. And your responsibility is to work towards the welfare of the people. As a government servant, as a public servant, as a civil servant, your responsibility is to implement those policies that were created by your political bosses. Meaning you will also strive to achieve the concept of the directive principles. And the ultimate goal is to work towards the welfare of the state. Am I clear? Next, I'm opening the document once again. Let's have a look at this. So through the DPSP, the Constitution seeks to achieve the ideals of democratic welfare state. Now, these DPSP constitute a very comprehensive economic, social, and political program for for the modern democratic state. What do you mean by this? Just a moment. Yeah. Now, when I use the word DPSP, it is not just acting in particular in one direction, but this is the comprehensive program which is including economic, social, and political programs for the modern democratic stage. The ideas of the principles is that realizing the high ideals of the justice, liberty, equality, and fraternity that are outlined in the preamble of the Indian Constitution. When I was talking to you regarding the preamble, I have used certain words: sovereign, socialist, secular, democratic republic. And after that, I used four other words also, which are considered to be very noble words. They are the justice, liberty, equality, and fraternity. And these four words are considered to be objectives of the Constitution, meaning the objectives of the Constitution are enshrined in the preamble of the Indian Constitution. Without giving justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and promotion of fraternity, promoting unity and integrity of the nation. In the absence of all these things, the ideas cannot be realized. The principles of the Constitution cannot be realized. That's the reason why the state of the day must keep all these things in the mind before it makes a policy. It should think about the justice, liberty, equality, and fraternity, then accordingly frame your policies so that that is leading to the welfare of the state. That is the meaning of the this particular line. Look at this. The directive principles of state policy are non-justifiable in nature. Just now I told you what is the meaning of this. They are legally not enforceable by the courts for their violation. See, basically, the idea behind this DPSP making the non-justiciability is that if you look at the DPSP, it is talking in terms of the social, political, and economic welfare of the society. And for everything, the government is expected to spend the money. Without spending the money, the developmental activities cannot be implemented. But if you go back to the year 1950, India was considered to be a poor nation. The government of a poor nation is not expected to fulfill each and every aspiration of the people, because different people in different areas will have different aspirations. But the government of the day should be acting in such a way where comprehensively the objectives that are enshrined in the Constitution are to be fulfilled. But on day 1, day 2, day 3, or within 10 or 20, 30 years, we cannot expect the state to meet each and every requirement that is demanded by the people. That's the reason why deliberately the DPSP was made non-justiciable. According to the convenience of the government, it will be implementing the policies for the social, economic, and political welfare of the people. But the government has to function. The state has to function. We cannot expect the state to be inactive at any given point of time. State should be always dynamic in nature. State should be always on its toes for working towards the welfare of the people. Whenever the state stops functioning, that is considered to be the collapse of the entire nation. That's the reason why in every country, in every democratic country, rather, the citizens request, the citizens aspire that our government should be a stable government. The people who are there in the government must be working with integrity. Then only the objectives that are enshrined in the constitution are completely fulfilled. Kindly remember all the points what I am talking to you. These are the basic tenets of the Constitution of India I spoke to you now. But what is happening in the reality? Why so many scams are coming into picture? If the ministers who are present in the power, if they are working for the welfare of the people, why there is a scam? Scam is nothing but these are the greedy people that are present in the state. They are looting the money of the people. They are playing with the principles of the democracy. More than the welfare of the state, they are looking at their personal welfare. That is considered to be the pathetic situation. If you just look at our history in India, I am talking about after independence, especially in the recent past, why so many scams are coming into the picture? Why so many high-profile people are thrown behind the bars nowadays? Why the Supreme Court is so serious against these people? How come they became the most important people in the country, in the political system? What they are supposed to do and what they are doing. This is what is happening. Meaning, the people who are there in the government, they are neglecting the concept of the DPSP. Forget about everything. The group that is present in the state, that is a part of the state, must work for the welfare of the people. For that reason, they are taking the salaries. So many emoluments and privileges they are enjoying. Still greedy, still corrupt. This is creating lots of nuisance in the country. A common man may not be in a position to understand this, but this is nothing but looting our economy. Previously, we used to criticize the British looted the Indian economy. But nowadays, our politicians, our own people, they are doing the same thing. Kindly think on all these lines. What is the meaning of the state? What they are supposed to do? But what they are doing? That is important for the examination point of view. Hence, while you are reading the newspaper, whenever you are coming across with any politician or any administrator with respect to any small concept of corruption or misusing his authority, that is considered to be the violation of the basic principles of the Constitution. Hence, they are liable for the punishment. They should be punished. Kindly remember these points. Now, I will open the document again. Look at this. Article 36. It defines the state and it made it very, very clear. It has the same meaning as given in Article 12 of Part 3 of the Indian Constitution. I told you during that time, in Article 12, the word state has been defined in an elaborate manner. But when it comes to Article number 36, it said a simple point. It has the same meaning as mentioned in Article number 12 of the Indian Constitution. That's it. Let me not repeat about the meaning of the word state. Next. Article number 37. Article number 37. Next article I'm talking to you. The directive principles are fundamentals in the governance of the country. It shall be the duty of the state to apply these principles in making the laws. We know that there is a state. State must make the laws. But how do you make the laws here? Whenever you are making any law, please keep these directive principles in mind and accordingly make a law. That's the reason why we are saying this DPSP are considered to be the fundamentals in the governance of the country. So what the state must do, that is explained elaborately in Articles 36 to 51. Hope you are getting it. Meaning what the government should do is given by the Constitution itself directly. But Remember, they are not justiciable. Look at this. Article number 37 also made it clear of that it mentions the non-justiciability of the directive principles. It made it clear that the judiciary should not compel the state to perform a duty under the directive principles of the state policy. Just now, I told you one thing. I was using a concept called judicial review sometime back. But when the government is functioning, if the state is not adopting any principles that are mentioned in the directive principles, court cannot compel the government to do this particular activity. Meaning the state has been given enough independence to decide. But at the same time, in democracy, what the people expect is that government cannot be inactive, government should be always active. If the government is not working for the welfare of the people, then who will work? That's the reason why government should keep on functioning. But whenever they are functioning, they have to keep the DPSP in the mind, and accordingly they are expected to function. That is the basic idea. But Constitution has given the protection to the state where the judiciary cannot give any directions to them with respect to any of the things that are present in the directive principles of the state policy. But when you are making a law, in that particular law, if you are trying to violate the fundamental rights, if the state violates the fundamental rights of the citizens, then only the judiciary will interfere. But judiciary cannot give directions to the state to implement so and so article in the directive principles, meaning the judiciary is not permitted. It was deliberately done by the constitutional forefathers by looking at the situation in India. India was a new country during that time. It just took birth in 1947, and we started the journey with constitution from January 26th, 1950 onwards. And in the beginning itself, you cannot put so much of pressure on the government of the day. That's the reason why. And it is impossible for the government of that days or those days to fulfill all the aspirations. But government should function. Just because the DPSP is non-justiciable, government or the state cannot ignore any principle that is present in the DPSP. Hopefully, I'm clear. You are getting all the points. Now, the non-justiciability is mentioned under Article number 37. Now, look at this. Article number 38 is considered to be a very, very important article with respect to the directive principles of the state policy. Look at this. The state shall strive to promote the welfare of the people by securing and protecting as effectively as it may a social order in which justice, social, economic, and political shall inform all the institutions of the social life. Very, very, very important. If you look at these words, justice, social, economic, and political, I was talking to you in the previous class when I was speaking about the preamble of the Indian Constitution. The same words are repeated here, meaning the state should always strive to provide this justice. 1, 2, 3, social, economic, and political, so that it can effectively protect the social order. Very, 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 very important. That's the reason why Article 38 is the very important article with respect to the directive principles of the state policy, because this article is giving the directions to the government to provide justice. What? Social, economic, and political justice. Am I clear? Kindly remember this one. Whenever you are writing the answers for the main examination, or if you are trying to write any question for essay writing, this article will play a very, very crucial role. Depending on the question, you can mention the number of article also. Look at this note. Article 38 is the keystone or the core of the directive principles. because you are talking about the justice. Next, Article number 39 is talking about the right to adequate means of livelihood for all the citizens. Equal pay for equal work for both men and women. Meaning, the state should always strive to provide equal pay for equal work for both men and women. So many times these complaints will come in our day-to-day life also. Women are paid less, whereas men are paid more. But it is the responsibility of the state should to see that equal pay for equal work for both men and women. Next, Article number 40. Under Article number 40, we are talking about the state shall strive for establishing or organizing the village panchayats. What do you mean by this village panchayats? Village panchayats are nothing but these are the governments at the village level. But kindly remember, today in India, under the constitution, we have we have a system called Panchayati Raj system. And when I'm using the word Panchayati Raj, I am talking about Zilla Parishad, Mandal Panchayat, and the village panchayats. This is Zilla Parishad and Mandal Panchayat are the new concepts in the constitution. But the concept of village panchayat was existing in India from day number one. The constitution is asking the state to organize the village panchayats so that a sort of government will be established at the village level, and the people in that particular village will get benefits of the government at that lower level. That is a basic advantage. Recollect the words said by Mahatma Gandhi. India lives in rural areas. So according to that great man, until and unless the villages are not developed, development of the nation is not possible. In order to develop the villages, look at this in India today, we have more than 6 lakh villages. How do you develop these villages? You have to concentrate on each and every village. But what do you mean by development of a village? When I'm using the word development, this is the holistic concept of the development. If you are just providing only drinking water, or if you are giving only electricity, or if you are giving only health facilities, that is not considered to be development. A development should be always holistic. Hence, the state should always strive for providing holistic and overall development of a village means every village should have communication system, regular supply of the power, that is electricity, drinking water, irrigation, education, public health, and remaining infrastructure. Everything should be available to the people at the village level. And if you provide everything to the village, then obviously people in the village level, they stop thinking of the migrating from one place to the other place. Because the facilities are not available, they will migrate. Employment opportunities are not there, then they will migrate to other places where they expect the employment opportunities will be available. Education facilities are not there, hence they are going for the migration. But the constitution wanted to address this problem from day number one by including article number 40 of the Indian constitution. And the village panchayat that is present at the village level should strive towards that. Hence, village panchayat is also a part of the state. We have understood. But who will establish? It is the responsibility of the government to create the village panchayats. This is the basic idea of article number 40. When we speak about the Panchayati Raj over a period of time, we'll have a detailed discussion regarding what exactly is the Panchayati Raj and how exactly the village panchayat at the village level will function. We'll try to understand. Let me move to some other article now. Look at this. Article 41 of the Indian Constitution. It talks about the right to work, public assistance in the event of unemployment. Kindly see here, you might have come across with certain things what I'm speaking to you. Even in case of unemployment, the public assistance is expected and the constitution is giving the directions to the state. But some of you may be thinking that in case of unemployment, the state is not giving any assistance. See here, this is a part of the directive principles of the state policy. Always keep in mind article number 37. That article 37 is also talking about the non-justiciability of the DPSP. Kindly keep that in the mind. If the government is working, if the government is providing everything, means the government is active in this particular area. Because of any reason, if you come across at any particular place that the government is not providing any assistance in case of unemployment, the government is not implementing this particular article. But it cannot be subjected to be challenged in the court of law. We cannot challenge in the court of law because of article number 37, because they are non-justiciable. If they are justiciable, I can approach the court and the court will accept my petition. But because they are non-justiciable, they cannot be challenged in the court of law. Am I clear? Next one, Article 42 of the Indian Constitution. The provision for just and humane conditions of work and maternity leave. So at every working place, there should be comfortable conditions and humane conditions of the work. At the same time, maternity leave should be provided. In every organization today, there is a facility for the women and they can avail the maternity leave. Few days before the delivery of the baby and after the delivery of the baby also, they can avail this particular leave. Meaning certain concepts are being implemented from the state by the state from day number 1. Next one, Article 43, it talks about the living wages for the workers. What do you mean by this? Whatever the wage, that is the money or the salary that you are paying to the workers, they should be sufficient for them for their living purposes here. And if the wages are very meager, how come the workers will support themselves and also the families? That is the reason why, as and when the economic conditions are changing, as and when the prices of the goods and commodities are increasing, accordingly the state is also expected to increase the wages. That is the basic idea in this concept. Next one, Article number 44 talks about the uniform civil code for the whole country. Now, what do you mean by this article number 44? Sir, when I am talking about the uniform civil code, this is the common code for all the people who are living in the country. Uniform, common. Civil, for all the people. Code, rules and regulations. All the people in the country must have the same rules and regulations. So many rules and same rules and regulations. So this is what we have understood from day number 1. We have one constitution and that one constitution is applicable for all the people equally. That is the equality before law and equal protection of the laws. But there are certain areas where The state has permitted different laws for different religions. India is a land of multi religions. So India has the capacity to adapt and accommodate so many religions that are present here. That's the reason why it is not just one, two, three religions that are present in the country. There are various religions that are present. In the previous class, I have used one word called secular. India is a secular state where there is no official religion. Whenever I am talking about a religion, different religions will have different values and different backgrounds, different ethics, different systems, different procedures. These procedures are not expected to be common. That all depends on the background of that particular religion. Yet, each religion has to be protected. Each religion, its values must be promoted. This is the responsibility of the state. That's the reason why deliberately in India we don't have any official religion. But the constitution is one that is applicable for all the citizens equally, irrespective of the religion, race, caste, creed, sex, or place of birth. But at the same time, there is a provision with respect to some subject matters. Different religions may have different acts. That is the reason here when it comes to marriage, divorce, and the property issues, different religions will have different acts. That's the reason why we come across with the Muslim Act, we come across with the Hindu Marriage Act. When I'm using these words, that is applicable only for that particular section of the society. It is applicable for that particular community only. But article number 44 makes it very, very clear. This Uniform Civil Code or the UCC must be present for the entire nation. If the article 44 is implemented, then different religions will not have different laws even with respect to these three subjects. All the religions will be coming under the clutch of the same law, but that is not happening in India today. But with an anticipation and expectation that in future we may go for the uniform civil code. So that is one of the directions that are given by the Constitution of India under article number 44. That is point number one. I'll just recollect one point. In the year 1992, the Supreme Court also made a comment saying that Article 44 has remained as a dead letter. When I use the word dead letter, it is nothing but there is a provision that is present in the Constitution but never used. In our long history of the Indian Constitution, no government has tried for implementing article number 44, where you will come across with the uniform civil code. And the government of the day is also not trying because it is related to the sentiments and values of the religions. Very, very sensitive issue. The people belong to a particular religion may be hurt. That's the reason why there was never an attempt by any central government in India with respect to implementing the concept of uniform civil code. Yet it is important. Some people will argue for implementing uniform civil code, and some people will argue against the uniform civil code. But whenever you come across with the uniform civil code concept anywhere, kindly read those points. That will be important for examination point of view and for increasing the analytical abilities. Again, I'll show you the document. Once again, look at this. Article 45 says that these are the provisions for the early childhood care and education to the children below the age of 6 years. I'm just repeating. Kindly look at the Article 45 very carefully. Provision for early childhood care and education to children below the age of 6 years. This is the content that is present in Article number 45. But if you remember this one, when I'm talking about the fundamental rights, I was talking about Article number 21A of the Indian Constitution. During that time, I told you that Article 21A has been added to the Indian Constitution through the 86th Amendment. And that 21A says that it is a fundamental right of the children to get the free education. Hence, the state must provide free and compulsory education to all the children. During that time, I told you, child is a person who is between 6 and 14 years of age. And anybody who is falling between 6 and 14 years of age, the state must provide free and compulsory education. That is the subject matter present in Article number 21A. But in reality, that particular line is mentioned under Article number 45 of the Indian Constitution. It is the responsibility of the state to provide free and compulsory education to the children between the age of 6 and 14 years. Originally, it is present under Article number 45. The government of the day, it was trying to provide the free and compulsory education. But always there was the criticism that there are so many loopholes with respect to providing the free and compulsory education. There were so many gaps. Over a period of time that there was a demand that whatever the right you are talking about the education for the children, instead of having that one in the DPSP, let it get shifted to the fundamental rights. As long as something is present in the directive principles of state policy, the people will be living on the mercy of the state. If the state is providing, then the people will enjoy. People cannot demand certain things from the state because according to their convenience, they will be providing all the facilities. But something, if it is mentioned under the fundamental rights, it will become a right of a citizen and the judiciary will come to the rescue of the person. That is the reason why Article 45 subject content has been taken out and a new article called 21A has been inserted into the Constitution of India. Meaning, a responsibility of the government became a fundamental right of the children today. Now the government is under pressure to provide free and compulsory education. Otherwise, we have every right to challenge the same thing in the court of law. This is the basic idea with respect to the article number 45. But still, article number 45 is present in the Constitution, but the subject matter is different. Kindly have a look at this. Previously, it was talking about the children between 6 and 14 years of age. Now also the Article 45 is present. It is talking about the children below the age of 6 years. I'll show you the document again. Look at this. Provisions for early childhood care and education to the children below the age of 6 years. This is what is mentioned under this article. Next one. Article 46. It talks about the promotion of educational and economic interest of the scheduled castes, scheduled tribes, and other backward classes. Look at this. Since beginning, these are considered to be the backward sections of the society. And obviously, the government is expected to pay more attention on these sections of the societies. Article 46 is asking for promotion of educational and economic interest of these sections. That is the reason why scheduled castes, scheduled tribes, and other backward classes, their promotion of educational and economic interest by the state are mentioned under Article number 46. Next one, Article number 47. It talks about the prohibition of consumption of intoxicating drinks and drugs. Important. It is the duty of the state to raise the level of nutrition and the standard of living to improve the public health. Now, for example, see here, when I'm talking about the intoxicating drinks and drugs, so we have a concept called liquor that may be in any form. And this liquor is spoiling the health of the people. But the state has been asked by the constitution to prohibit this liquor. But how many states have prohibited the liquor? Very few states. Because for most of the states today, the liquor is playing a crucial role for their economy. They are earning huge revenues by selling the liquor. Hence, in most of the states, the liquor is very much available. In very, very few states, it's not available. But it is the responsibility of the state to prohibit this liquor so that you are protecting the economy of the families. At the same time, the state is also protecting the lives of the individuals. This is what is mentioned under Article number 47. But most of the governments have failed to implement this because this is generating huge revenues for them. Recently, you might have seen Kerala government has announced the prohibition of the liquor. In Gujarat, it is prohibited. In some other states, if you look at them, liquor is very much available. And especially when it comes to a common man, after a long day's work, whatever he is earning, unfortunately, majority of the people, they are spending this money on this liquor or cheap liquor. If the money is wasted like this, then their healths are getting spoiled. And at the same time, who will take care of the families of those people? Children, education, health, everything. Who should take care? Hence, that is the reason why the government is expected to prohibit the liquor, but majority of the states are not doing this. We cannot do anything. For example, let me tell you, in the year 2012, a person from Tamil Nadu approached the Supreme Court and requested the Supreme Court to give the directions to the Tamil Nadu government so that they will be implementing the prohibition of the liquor. But the Supreme Court has rejected to take up this case. It is because it's a part of the directive principles of state policy. Instead of that one, the Supreme Court advised the concerned person, why don't you start thinking on something? In Tamil Nadu, so many road accidents are taking place. Why don't you think on those lines how to reduce, how to stop this, how to reduce the road accidents? Meaning the court has refused to accept this petition. This is what happened. This is a live example. Now, let me show you the document. Some more points we have. Look at this. In India, states like Gujarat, Manipur, Mizoram, Nagaland, and Lakshadweep prohibited manufacture, sale, and consumption of alcohol. In Gujarat, the law is in force since May 1st, 1960. Gujarat is the only state in India that has the death penalty for those who found guilty of making and selling spurious liquor which causes the death. This was done by amending the Bombay Prohibition There is Gujarat Amendment Bill 2009. Kindly remember this one. So these are the states where there is no liquor. Gujarat, Manipur, Mizoram, Nagaland, and Lakshadweep. Look at this. The Bombay Prohibition Act of 1949 is still in operation in both Maharashtra and Gujarat. Look at this in Lakshadweep. Just now I told you, in Lakshadweep, it is prohibited, right? But there is one island called Bangaram Island. That is the only place. That's the only place in the Lakshadweep. There are so many islands in Lakshadweep, but one island is Bangaram. This is the only place where the consumption is permitted. Sometimes some few words I have here for you can just have a look at this. You have some concept called dry days. These are the days on which the sale of liquor is banned and not the consumption. Consumption is permitted, but sale of liquor is not permitted. Look at this. Impact of prohibition in Haryana. Example, I am giving it to you. After the 1996 assembly elections, the Haryana Vikas Party imposed ban on liquor by the Chief Minister Bansilal, and it had a very bad impact in the 1998 Lok Sabha elections, where it won only one Lok Sabha seat out of 10. So sometimes the effect may be positive or negative, and this is the effect that was there on the government because the government imposed prohibition. And in the year 1998, the government of Haryana has lifted the ban. Whether to impose the ban or lift the ban can be decided by the government of the day. Getting it? Look at this. Article number 48. This article talks about the organization of agriculture and animal husbandry and also the prohibition of the cow slaughters. Recently, what I've seen, Haryana government has announced that it is going to make a legislation where cow slaughter is prohibited, and the people who goes for the cow slaughtering will be punished according to the law once the legislation is made. At the same time, the state is also expected to organize agriculture and also the animal husbandry, that is under article number 48. Under article number 49, the state will give protection to the monuments, places and objects of the national importance. So under the provisions of this article, the state always tries to give the protection to the all important monuments, places and objects which are of national importance. Next, when it comes to article number 50, look at this. It talks about the separation of the judiciary from the executive. What do you mean by this? So this is one article that is imposed, that came into effect from day number 1. When I'm talking about the judiciary and executive, implementing authority should be separate from the inquiring authority or the authority which gives the punishments. Otherwise, before the independence, the concept of both judiciary and executive functions are vested in one authority, that is called district collector. Just imagine a situation, the same person is implementing and the same authority is also looking whether the implementation is correct or not. If these two powers are located in one particular person or one particular authority, how come you will provide the justice? That is the reason why the judiciary has been separated from the executive from day number 1. That is article number 50. Next, article 51, it talks about the to promote international peace and security, just and honorable between nations and a respect for the international law. It is not just internal peace and security, The state should also promote the international peace and security. That is another important point. Next one. Look at this. I have some point here. The 86th Amendment of 2002 changed the subject matter of Article 45 and also made elementary education a fundamental right. Just now I told you. This came into effect on April 1st, 2010. With this, the children between the age group of 6 and 14 are entitled for free education. Look at this next point. B.N. Rao, I told you about this great man. He was the advisor, constitutional advisor. He recommended that the rights to be divided into justifiable and non-justifiable. Accordingly, part 3 and part 4 came into the picture. Meaning, according to him, all our rights, everything that is mentioned in the DPSP are also the rights. But they should be divided into justifiable and non-justifiable. That's the reason we are coming across with the part 3 and part 4 of the Indian Constitution. Next, look at this one. I was telling you one point. There is always a contradiction between the fundamental rights and the directive principles of the state policy. The state is always talking in terms of the DPSP. They are giving high priority to the DPSP. If we implement the DPSP, then only the welfare of the state is possible. But when it comes to the Supreme Court is always talking in terms of protecting the fundamental rights of the citizens. On the name of making a law, if there is an infringement to the fundamental rights, that cannot be tolerated. Hence, the Supreme Court from day number 1 is giving highest importance to the fundamental rights. And the state, the governments are giving highest importance to the DPSP. And this is causing a dispute between the judiciary and the state, the judiciary and the executive, the judiciary and the parliaments. With respect to that one, we have certain case laws. Kindly look at them. Look at this. In Champakam Dorairajan case of 1951 CR, this particular contradiction started long way back in 1951. The Supreme Court ruled that in case of any conflict between fundamental rights and DPSP, the fundamental rights would prevail. Kindly remember this, meaning the court given high priority to fundamental rights. In Golaknath case of 1967, the Supreme Court held that the fundamental rights cannot be amended for the implementation of the DPSP. Meaning, again, the court has given high respect to fundamental rights. From day 1, it is giving protection to the fundamental rights at the higher level. Right? Next. Come across the next one. In Keshwananda Bharati case, the Supreme Court declared that there is no essential dichotomy between fundamental rights and the directive principles. They complement and supplement each other. Another fantastic judgment given by the Supreme Court. Kindly remember, look at this. In the first case and the second case of 1951 and 1967, the Supreme Court made it clear that fundamental rights will be given the high priority. But the Keshwan and the Bharati said that they are complement and supplement each other. Important. So this is how the judiciary, the judges that are present in the Supreme Court on that particular day, whatever the judgment they give, that will become the final. If the new judgment is against the old judgment, the new judgment will prevail. Okay? Next. One second. The 42nd Amendment of 1976 accorded supremacy to the directive principles of state policy over the fundamental rights. Meaning, Constitution can be amended by the Parliament, and by amending that, you can decide anything. That's the reason why through this amendment, the Parliament tried to give supremacy to the directive principles over the fundamental rights. But In Minerva Mills of 1980, the status of DPSP was made subordinate to the fundamental rights again. In the sense, whatever the change that was made by the parliament, it was nullified by the Supreme Court. This is how the contradiction will go on. Look at this. I have some points here. You can just read it here. Some miscellaneous points. Dr. B.R. Ambedkar's statement on DPSP in the Constituent Assembly. Here, I have given these statements. If you read and understand these statements, we can understand the importance of that particular subject. Look at this. According to B.R. Ambedkar, it is the intention of the Assembly that in future, both the legislature and executive should not merely pat the lip service to these principles enacted in this part, but they should be made the basis of all executive and legislative action that may be taken hereafter in the matter of the governance of the country. So this is what he said. Lip service in the sense, it is not just saying something, but Dr. B.R. Ambedkar was also insisting on the dynamic part of the government. So whatever the action you are taking, maybe the legislature, maybe the executive, in the governance of the country, you should use these principles in the governance. That is the thing that was highlighted by Dr. B.R. Ambedkar. And the same gentleman has given one more thing. The directive principles are the novel feature of the Indian Constitution. The directive principles, along with the fundamental rights, contain the philosophy of the Constitution and is the soul of the Constitution. Kindly remember, sometimes you will come across with the words philosophy of the Indian Constitution. Whenever I am using the word philosophy, we are talking about the fundamental rights plus the directive principles of the state policy. So these are the statements that are given by Dr. B.R. Ambedkar. Look at this next one. Dr. B.R. Ambedkar has given another statement. A state just awakened from freedom with its many preoccupations might be crushed under the burden unless it was free to decide the order, the time, the place, and the mode of fulfilling them. Very, 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 very important. Meaning Dr. B.R. Ambedkar, he was talking in terms of both fundamental rights and also the directive principles of the state policy. But he himself was giving high priority to the directive principles because he was insisting and he was trying to remind the people that we just got awakened, meaning we just got the freedom. And in a new country, in a new state, if the new government is not given enough freedom to what to decide, when to decide, where to decide, and how to decide, the entire state may be crushed down. Meaning you cannot put so much of pressure on the state. Hence, enough freedom has to be given to the state. This is the statement that was made by Dr. B.R. Ambedkar. Hope you are following this one. Very, very, very important. That's the reason. If we are reading, the Constitution was prepared by sitting for 2 years, 11 months, and 18 days. That is not the end of the story. Those people, those great people, they worked for a long period of time, long number of hours. They discussed each and every word, each and every concept. And finally, they have come out with an elaborate constitution. Everything was discussed on the floor of the Constituent Assembly. This is the beauty of the Indian Constituent Assembly, which framed the Constitution. Everybody was a great person during that time. Lucky, India is really lucky to have such type of people in India, and because of them only we have a nice constitution today. Look at this. Again, Jawaharlal Nehru's statement in 1951. The DPSP represent a dynamic move towards a certain objective. Yes, this is what we understood. Operative part of the government. And the fundamental rights represent something static. To preserve certain rights which exist, both are right, but somehow and sometime it might so happen that the dynamic movement and the static standstill do not quite fit into each other. This is the statement that is given by Jawaharlal Nehru. Directive principles are dynamic, fundamental rights are static. But a situation may be arisen where these two cannot fit into each other properly. Meaning he was also talking in terms of more priority to the DPSP. Look at this. The Supreme Court held that the Articles 38, 39, and 46, it is the duty of the local bodies to implement the directive principles in a planned manner by annual budgets by providing a right to right to resident to the poor. Important, I'll come to this once again. Article 38 is considered to be the key of the directive principles. By invoking the provisions of Article 39, 41, 47, and the Child Labor Act of 1986, the Supreme Court in the year 1997 held that the offending employer should be asked to deposit 20,000 rupees in a child welfare fund for each child employed, and the state should also deposit 5,000 rupees. What do you mean by this? This is a mechanism through which you protect the rights of the people, rights of the children. Employment of the children should be considered to be violation of the principles of the Constitution. If any employer employs a child, then under the provisions of 39, 41, 47, and also the Child Labor Act of 1986, the employer should deposit 20,000 rupees and the state should deposit 5,000 rupees, and the money should be used for the welfare of that particular child. Look at this. Next one. The international treaties do not automatically become the part of the national law. These have to be adopted by the legislations. Hence, India, if you decide something else outside India, that will not automatically become a law. Again, for implementing that one, you need to come back to our legislatures and you have to decide by adopting a legislation. And this comes under the jurisdiction of the Union under Article 253. Meaning, every time the central government need not talk to the state government with respect to the international treaties. If you decide something outside India, or if you decide something about the international treaty, that must be accepted by the parliament, and that can be implemented by passing a legislation in the respective parliament. And this is the exclusive jurisdiction of the union under Article 253 of the Constitution. And Dr. B.R. Ambedkar was strongly in favor of uniform civil codes, and he was the person to say that as early as possible, this UCC, Uniform Civil Code, has to be implemented. This is the statement made by Dr. B.R. Ambedkar. Next, look at this. We have some more points. In S.R. Bommai versus Union of India case of 1994, the Supreme Court urged the government to enact a uniform civil code to promote national integration. It is only a suggestion that was made by the Supreme Court, but Supreme Court cannot give a direction. Kindly remember this. This is what happened. Meaning the Supreme Court also expressed its opinion saying that uniform civil code has to be implemented to promote the national integration. Otherwise, on the name of different laws, the society is also divided. Look at this. The Supreme Court in the same year 1994 stated that Article 44 had remained a dead letter. The preamble, the fundamental rights, and the DPSP are the integral parts of the Indian Constitution. All the three are meant for building an egalitarian society and in the concept of socio-economic justice. Meaning in India, socio-economic justice will come into the picture. It will be completely, the dream will be fulfilled only when we build an egalitarian society, that is the equality in the society. That is possible only when we completely understand and implement the principles of preamble, fundamental rights and the directive principles. Look at this. If the fundamental rights represent don'ts, the DPSP represents the do's of the executive and the legislatures. Then there is a conflict. Look at this. Jawaharlal Nehru's statement in Parliament in 1955, another one. The responsibility for economic and social welfare policies of the nation should lie with the Parliament and not with the courts. In case of contradiction, it was the Parliament to remove the contradiction and make fundamental rights subserve the directive principles of the state policy. This is what is happening since the beginning. Court in favor of the fundamental rights, but the state is in favor of the DPSP. That is the reason why various statements have come into the picture. Look at this. I think some news here. You can just go through this one later. That is already available. This is given by a sessions court in Delhi on forced marriage of a Muslim woman. Right? You can read this point on your own later. It is only some latest current affairs issue I have given. Otherwise, I'll read it for you. The statements were given on January 1st, 2013, while dismissing an anticipatory bail application moved by Maulvi, who was accused of forcing a young woman girl into a wedding with a married man, who allegedly raped her subsequently. According to Maulvi, the Sharia permitted a Muslim to keep 4 wives at a time, and the girl consented to the marriage. The judge, Kamini Law, noted that the girl had not signed the marriage certificate. Her parents were not present, nor were there any witness. According to the judge, the Indian legal system provides sufficient space for religious freedom. But whenever any such a regressive religious practice come into conflict with the rights of the citizens as enshrined in the Constitution, it becomes obligatory for the courts to ensure that it is the majesty of law and the constitutional mandate that prevails. Judge made it very clear that in Islamic societies, polygamous marriages are permitted, but only in certain circumstances. Yes, the judge has said very clearly that Islamic societies, polygamous marriages are permitted, but only in certain circumstances. That is, primarily in situations where a man's death has left his widow with no means or support. Polygamy is neither mandatory nor encouraged, but merely permitted. The Quran's conditional endorsement stresses that self-interest or sexual desire should not be the reason for entering into a polygamous marriage. It is a practical duty that is associated with the social duty of Islamic men to protect the social and financial standing of widow and orphans in their community. It's a beautiful judgment that is given by the court. Okay. So this is with respect to the directive principles of the state policy. And kindly read all the points once again very clearly and very carefully. One is the fundamental rights. Second one is the DPSP, where you are expected to pay lots of attention on this. And tomorrow, again, I'll come back to you with again the same DPSP, and we'll try to look into each and every article in a very, very detailed manner. Right? So that's nothing but a review. But before going into the detailed manner, you have to go through the whole DPSP once again today. If there is a possibility, also read fundamental rights, because I have shown you some case laws where there is a contradiction between DPSP and the fundamental rights. And the case laws will be thoroughly understood to you only when you know the basic things that are present in the fundamental rights and the DPSP. Am I clear? And I'll stop the class today. And thank you so much for being with me this morning. And see you tomorrow morning. And I wish you all a very, very good luck and have a fantastic day. Thank you so much.